Good morning, everyone, and welcome to Tuesday, August 25th. This is our part of the League California Cities COVID-19 webinar series. We haven't done one in a few weeks, so we are very excited to do one now. Today, we'll be talking about COVID-19 phase reopening, state and local code enforcement issues that are related to the First Amendment challenges. COVID-19 has rapidly changed the way that cities operate. And in order to meet these moments, the League has been producing this webinar series for you to learn from each other. So please ask questions during this presentation. So COVID-19 is presenting a lot of legal challenges in relating to enforcement, state and local level regarding the executive orders, public health orders, and reopening plans. Cities are having to deal with this on the front line. And today our presentation is going to address laws governing these issues, state and local enforcement toolkits available, and guiding some of the legal framework. So we have two amazing attorneys that are going to help you with all of that. Next slide. Before we get started, let's do some quick housekeeping notes. Please make sure that you are connected to your audio. You can do this by clicking on the audio settings. All lines have been muted upon entry, and this webinar will be recorded so you can listen to it at a later date. Next, how to ask a question. So there's two ways to ask questions. You can both verbally do it, or we can do the Q&A button. So on the bottom of your screen, there's that Q&A button. Just type in your name and your question, and we'll try to get to as many of them as we can. You also can upvote, and that means if you see a question that you wanted to ask, just hit that little thumbs up, and it will increase the chances of us asking it. Next slide. So we have two amazing speakers today. We have two Myers-Nave attorneys who practice within the First Amendment practice and trial and litigation practice. Our speakers today are Deborah Fox, who is the chair of the Myers-Nave First Amendment practice and trial litigation practice. And her practice includes appellate work in the state and federal courts, as well as administrative hearings and other proceedings before regulatory agencies. And our other speaker is Meg Rosequest, who is a counsel there, is a senior attorney. Her practice focuses on litigation and advisory work that emphasizes on the complex constitutional law issues. We have two amazing speakers who are here to talk so much about First Amendment challenges, and we thank them for their time. I'd like to turn it over to Deborah. Deborah?
Thanks so much, Megan. It's such a pleasure to be here, and I want to do a shout out to begin to the League for putting together these seminars on COVID-19. When Megan was asking if we were ready, I was thinking, you know, COVID-19 really doesn't ask that question. And so here we all find ourselves facing this crisis. We've all become crisis managers. And I think we probably should just pause and set the stage here. I mean, it's the pandemic, it's the wildfires, it's the Black Lives Matter protests. That is really staggering. And I think that folks that are here are just on the front lines. And I think we have to give ourselves a lot of credit, especially you folks who are dealing with the issues that are just so raw and difficult. It's really staggering. So what we hope to do this morning when we cover this ground is to give you some tools so that when you're dealing with these issues that are so critically important, not only are you dealing with people's public health, but you're dealing with their potential livelihood, their economic livelihood, and their potential life. That is really a lot to hold in one's hand. So I'm going to urge everyone to follow the League's practice and collaborate. Think about the tools we already have and we've used over the years, and we'll talk a little bit about those. I have to say as well, I don't think Megan gave any disclaimers, and I have to do a few. One is there is no magic bullet here. I wish there was. Code enforcement, I was talking with Meg at the beginning of this. the beginning of March, we knew this was going to be a big issue. It is a big issue, and it's just getting bigger. So hopefully, we hope that we can give you some tools, and you will feel like you can go to those as resources to address these issues. I wanted to give it just a little bit of background on Meg and I and what we've been doing the last 5 months to give us a little street cred here of the shelter in place. So we've been doing a lot of the federal litigation that has been filed by both churches and businesses in federal court. We have also been dealing with the requests for enforcement from local entities across the state. We've been drafting declarations from public health officers. And so we have really been in the throes of it. As well, I was thinking about my background, just as I was telling you to draw on yours. And one of the things that I've done over the years is some high-profile code enforcement. And so I thought, have I ever had to hold anyone in contempt for violating a zoning code? And actually I have. So one of the experiences that I wanted to share with you, just to give you a little bit of background of what we bring to what we're offering this morning, is 2 cases. One, a few years ago, more than a few, was an adult use operator who violated the no lap dancing. We had to get an injunction against him to comply with the lap dancing. He still didn't comply. We went into court. We got an order to remove the instrumentalities of the nuisance, which meant we took out the couches, believe it or not. He still didn't comply. Next to us, we could take out the audio. He still didn't comply. And so we filed for contempt. It was the first time in my legal career, and the only time in my legal career, I saw someone have to be cuffed and taken from the courtroom for violating a civil order. It is a rarity, but now we see in the news a lot of actions for contempt. The other item that I also just recently did was an injunction for a gentleman who was, and I use that term loosely, depositing over 800,000 cubic yards of debris into a canyon. It was against the zoning code. To make a long story short, we ultimately got a $6.6 million judgment and a revised preliminary injunction. But we had a lot of political pressure to go for contempt. And I'm sure that many of you will face similar pressure. So I hope, again, some of this discussion will help you work through that. Let me move to the next slide, if you would, Teresa. This sets the context. Context is always important. It's staggering when you look at these numbers. Almost 650,000 cases in California, 11,700 deaths approximately, and rising. I offer this to give it to you when you are thinking about looking at perhaps how you might change your municipal code for enforcement. Maybe you need some findings. Maybe you need a declaration if you actually get drawn into court, or adoptions of some of your emergency measures. Also, to bring it home to the league and our municipal family, one of the early super spreaders, and we can go to the next slide, please, not shown on this slide, but it was at the Trump National Golf Course in Rancho Palos Verdes, where the elected mayor of Rancho Palos Verdes was having her birthday party. That was before the shelter-in-place order of March 17th. And at that point, people were certainly not wearing masks, and there was not clarity. Ultimately, many of people got sick at that party. There were electeds, including the Board of Supervisors, and ultimately one person died. This is serious issues. We all know about super spreaders from reading the scientific literature, as well as the newspapers and the media coverage. Churches with their singing and chanting, and that is a big area of litigation right now. We've also seen the report out of East Lansing, Michigan. It's kind of my rival, but I'll talk about it anyways. Michigan State University, where they had this huge outbreak, 40% of university students. We are seeing and reading that in the news right now as universities open their doors. I was just reading the articles this morning about USC, and the numbers are staggering. If we might move to the next slide. I did want to also do a shout out if you are trying to find out what might be going on in the courts or what might be the latest attack that's happening. It's not on the slide, but it's a Twitter account by a very robust advocate for the plaintiff's bar named Harmy Dillon. She posts where she's going to go, who she's going to sue, and what legal action she's going to take, or what position she's going to take against public entities and the restrictions that are in place. So you can look at her Twitter feed. Sometimes I find TRO papers she's filed against my clients there before they're even on the federal platform. Here is the pandemic, some of the key timelines. Because we are a little short on time, I'm going to talk about two issues. One is the compliance strike team that has been formed by the state. I'm not hearing a lot about actual action by the strike team, so I'm looking forward to hearing some of your questions. Maybe you can tell us if any of you folks have actually gotten the strike team to take enforcement action. We've heard them going to visiting communities and doing study sessions, so it's great to partner with them, but can we hear a little bit more about how we get them to spring into action? We're all also awaiting for the next phase of the reopening. The governor says that should be coming soon. I'm going to predict it'll come out on a Friday night or maybe Sunday night, because everything happens on the weekend during COVID-19. If we might move to the next slide, please, Teresa. This is what we're going to cover today, okay? That's a lot. State enforcement, local, face masks, mechanics of enforcement. We'll go through some of the key issues that we're seeing in enforcement. If we don't hit on yours, please give us a question. Hopefully we'll have 10, if we're lucky, 15 minutes to talk about questions at the end, and we'll hit on your particular issue. If we might move to the next slide. This is state enforcement, and Teresa, we can go one more. So Newsman, and here is his funding threat. He said, we've made contingent $2.5 billion in the budget, and if local communities aren't willing to comply, then we'll use this as a velvet glove to try to get compliance, and ultimately, if you won't comply, we'll give your money to someone else. So let's move to the next slide and see what's been happening in that regard. Here are the particular funding buckets that the governor has been talking about. Not only FEMA and the disaster resistance funds, but the allocation within the 2020-21 budget. And if we might move to the next slide. What has been happening with the state enforcement? First off, many of you probably received the letter from the governor on July 1st advising all electives of their obligations to comply with these state shelter-in-place orders and to enforce them. The letter also called out the fact that failing to comply would be a misdemeanor under the Emergency Services Act. Clearly, the governor is using his velvet glove here. And here are two communities that have actually received specific letters from the governor about withdrawing their funding. One was the city of Atwater. That community adopted a resolution on May 15, declaring themselves to be a sanctuary city for businesses, for all businesses. The resolution says the city shall, quote, not take any direct action against businesses or individuals based on the actual or perceived business status. And this was, I believe, part of their effort to say all businesses are essential. And July 23rd, the OES wrote to the city manager and advised them that they needed to rescind their resolution or the city would be ineligible for funding at the tune of some $387,000. So I checked in with Atwater, and Atwater says they have absolutely no intent of rescinding that resolution. I have not had a chance to talk to Coalinga. I looked over the attendees this morning. I'm not sure we have any good folks from that community. I heard a rumor that I haven't been able to verify that Coalinga may sue the governor about and the state about this withholding of funds. So we should watch for that. What I want to bring out to you, though, is the interesting fact that what the governor is saying and the state is saying to local entities is you can't make this official declaration in a resolution or ordinance, an affirmative action declaring that you are not going to follow the dictates of the state shelter-in-place order. Now, how far that might go, we don't know. Whether or not simply public statements by public officials would be sufficient to trigger this. But at this stage in the game, we only have the evidence from these two communities that had adopted a resolution or ordinance. And in that particular case, the governor said, because you had to certify as part of your compliance that you had not adopted an ordinance or resolution of this nature, now you are in violation of the shelter-in-place ordinance. So we should keep an eye on this for where this line is for the state enforcement at the local level. If we might go to the next slide. So moving to this, I wanted to talk a little bit about local enforcement, which I'm sure might be of interest to you this morning. So here are the priority enforcement actions that concerns that we put together, Meg and I were thinking about. Face masks. 2 weeks ago, it seemed face masks was really of utmost concern. I'm still hearing that there are issues that abound in local communities about folks who don't want to wear face masks. Those of you who are boots on the ground, I'm sure are facing this. We've all seen the videos and they are pretty ugly and pretty difficult in getting folks to comply and to educate them. The other big issue is in-person religious services. It's certainly been a hot topic in the courts. We have salons and beauty services. Everyone is concerned about getting their hair cut and looking good on their Zoom call. Finally, we have bars and restaurants, and we have schools. I would call out that just salons and bars and restaurants are a little easier enforcement, if anything here is easy, because of the fact that they have permits issued by the state that can be revoked. If we might move to the next slide. I call this the face mask conundrum. And if we might go to some examples here. These were some of the original jurisdictions that imposed various fines for not wearing a face mask. You can see in Marin County, West Hollywood, Napa County, County of Los Angeles, etc. And then the next slide shows some of the newcomers to the face mask citation. Here you have Hermosa Beach and Manhattan Beach, not too far from where I'm here, sheltered in place. Hermosa Beach retained Wildan Group, and I'm sure many of you use them for your planning or building review, and now they are being used in this beach community to provide assistance for enforcing the face coverings. We've had some stats here too about the number of warnings that have been issued, handing out face masks. Many of these are done in particular geographic areas, like at the pier or near the ocean. And I would say anecdotal, I have stopped going to the beach walk because of the lack of face masks, but I have noticed in the last few weeks that has improved. In any event, the next slide, please. Here is what some of you may be finding in your community. This is the Merced County Sheriff. Here was his position on May 16th. He was saying, hey, nobody's got the right to tell me what risks I can and can't take, what I have to wear. I am not going to be taking any enforcement action against anyone for COVID-19 violators. I'm not going to be the face mask police. We've heard others say I'm not going to be the church police. The Merced County Sheriff had a change of heart some 45 days later. And if we might go to the next slide, Teresa. Here he's saying, you know, I've seen the light. This is a very serious disease. The mask is effective. I have one in my truck. I have one in my work truck, my personal truck, at home. Do the right thing, wear a mask. I think it kind of highlights how everything is changing here. One time we were told face masks are not needed, then later on, and now we're told they're very key for stopping the spread of this very infectious virus. If we might go to the next slide. It always raises the question, I'm sure you've heard them, whether you've watched the woman Karen at Costco or individuals at Trader Joe's and other facilities saying, I have a constitutional right not to wear a face mask. So then Meg and I decided, well, is that a protected speech? So here's two examples. You can see clearly the woman on the left is wearing a Black Lives Matter face mask. I'd like to focus my discussion this morning on the woman in the bottom right who is not wearing a mask and tell you the legal rubric that applies here. And if we might move to the next slide. So the question is not wearing a face mask protected speech? And it's a two-pronged test. Can you see an intent to convey a particularized message? And would that message be understood by the viewer? And so, Teresa, if I might ask you go back one slide to the folks in the mask. So here you can see the argument is clear. I think that Black Lives Matter is clearly a political message. It would be received by a viewer and understood to be communicating such. While the woman below, who looks like she's looking at her phone, it appears to me that she's standing in front of liquor. So perhaps she is upset that she can't find the beverage of her choice, but it certainly isn't clear that not wearing a face covering in that photo provides any particular message. And then if we might jump 2 slides up, Teresa. So here's a case for those of you who want some legal authority for this that we pulled. This is a case out of Washington from Bottoms Up Espresso. I'm sure everyone's missing going to the coffee shop of their preference. This is was located up in Washington, and this particular barista was clad only in a bikini, but at Megan's request, we showed a little more attire here. And she said, you know what, my message is I accept my body, I have fearless body acceptance, you know, woman empowerment. And the court ultimately rejected that. The Ninth Circuit said, you know, plaintiff's wardrobe choice didn't constitute expressive activity. And if we might move to the next slide. This is another case that I thought was interesting, again, about having to put on a particular accessory. And this was a individual from Orange County that said adding a helmet was a violation of his constitutional rights because he couldn't do so safely over his religious head covering. The court rejected that argument and said operating a motorcycle is not expression, and the impact on the turban wearing was incidental to this valid law. There's a couple of areas that we'll see in case law about wearing gang colors from the Gilroy Festival. That case, ultimately, the Ninth Circuit dodged the bullet and didn't give us any useful information there. So I offer these two cases for you if you do get into those disputes about face masks. We'll go to the next slide briefly, please, Teresa. This is the mask conundrum revisited. And this is just how you review the issue and whether or not you have legitimate health and safety concerns. And so that it might be appropriate when you are drafting, if you want to do an ordinance or documents confirming fines for not wearing face masks, talking about the health concerns and citing to the scientific evidence that is now clear that wearing a face mask does prevent the spread, and particularly from asymptomatic people who don't even know that they are ill. And if we might go to the next slide. Mechanics of enforcement here, and moving one on, Teresa, please. Here is an individual that you may recall from what was an entity called American Apparel. He gained fame on Saturday Night Live. This gentleman, and again, I'm using that term loosely, was forced out of his company because of his improper sexual behavior, inappropriate sexual behavior, and harassment of his employees. He reinvented himself as an essential worker. He had a factory in Los Angeles. Ultimately, it was shut down. 300 plus infections, 400 deaths, an expose in the LA Times. It was really a very serious issue, and this is one of the first instances I know of a business being shuttered because of their lack of compliance. If we might move to the next slide. Here is something that's recently been discussed and declared by Mayor Garcetti. He says that first, the goal of the city of Los Angeles is to educate, but if we can't get people to understand the issues at play and they continue to have parties in the Hollywood Hills, we are going to turn off their utilities. There was such an offender. I'm not sure if many of you are on TikTok or know about TikTok, but you can check in with your 20-somethings. So TikTok and their influencers have these homes in the Hollywood Hills. They've held several parties. Ultimately, their utilities were turned off. I would posit a couple of questions. One would be a legal and one would be a practical. The legal question I would posit is whether or not there's any due process concerns here. So if you are thinking about doing this, I would urge you to make sure that you have the legal authority to do it. So check back with your city attorney. If you really think this is something you want in your arsenal, I'd make sure that your municipal code or other written provisions allow for the termination of utilities, and they do so with procedural safeguards, especially when we find ourselves in 100-degree weather. And then my practical question would be how effective for a TikTok influencer is it to turn off his utilities when he moves yet to another large house, rents it, and has another party? So wouldn't it be more effective if we could find an enforcement way to impact his sponsors who give him his brands and is certainly the money flow there? I did get a call from the Daily Journal about this issue and just learned, it was either yesterday or the day before, that there's been a federal lawsuit filed against the city about terminating utilities. I don't think that case is going to survive in federal court, but we should keep an eye on it in case it does give us any information about this issue. And if we might move to the next slide, Teresa. Okay, here's the big one, how to set up an enforcement case. Okay, I just decided to go for big sort of foundational issues to help you along here. Obviously, the first one is always seek voluntary compliance. I know that that is a practice of most jurisdictions throughout the state, trying to educate people and get them to comply. One of the problems here is timeliness. So in other issues, if we have someone who has an overgrown lawn or parking, vehicles on the front lawn, other issues, we could take a long period of time to get compliance and try to get education. Unfortunately, COVID-19 doesn't give us that luxury of time. So I would ask you to and urge you to take a look at your municipal code to see what current provisions you have for your ability to take enforcement, your ability to inspect, your ability to take pictures. If you're going to move forward with enforcement, it is critical that you have photographs of the violations. And I'll say that again, it is critical you have photographs of the violations. So you need to take a look at your code and make sure you give your code enforcement officers the citation to the particular code section that would let them go in. So when the business owner says, I want you to leave, they say, I have the authority under the municipal code to be here. I will not interfere with your business that is probably operating outside, but I have the authority to be here and to take these photographs. I would also urge you, when you're thinking about this, about even-handed enforcement. I did some examples of the Black Lives Matter versus outdoor church. Another one that comes to mind most recently is the TikTok influencer versus USC, where there was just a party with over 100 people that's been reported extensively in the LA Times. I'm sure many of you have had party houses or had venues where people are holding weddings, and those sorts of enforcement issues you've dealt with before. It's the same application, but again, the stakes are a little higher here because of or a lot higher here because of the public's health issues. So think about your even-handed application. Proceed to gain evidence of the violations. Again, look at your established process, follow your established process, figure out if you need to revise your established process. We always have to update our codes to deal with new issues, and that may be the case here as well. If you need to, you may need to consider going to court for an injunction. There's the option of state versus federal court, or I wish there was the option of state versus federal court. If you have a vehicle to get into federal court, I would urge you to do so. State court is notorious for not being comfortable with dealing with constitutional issues. They many times are a little flustered when they hear First Amendment and kind of hands off. They want to make sure they don't make a wrong decision. And so they're very, very reluctant to issue a TRO or an injunction. In contrast, federal court deals with this day in and day out. And then the big issue, what do you do if violations persist? I would say that we have to realize that as part of the no magic bullet, anytime you have a court order, to have compliance, there has to be some real underlying respect for that order. And if you don't have that, it is a very difficult position you're in. Contempt is a high burden. I would also urge, remember there's civil contempt, which is fines versus jail. No court's going to want to jail folks as a practical matter. It's just almost unheard of. And so with some folks, the leverage of the fine could be an effective enforcement. So again, I would huddle with your management team and your city attorney to figure out the best way of proceeding for enforcement. And with that, I'm going to pass the baton to Meg to tell us how this all works out in actual reality with a case study.
Thank you, Deborah. And I will move now to an example of a case study to look at the particular challenges with enforcement that we face in this COVID-19 environment. And for this, I chose a case out of Ventura County that involves Godspeak Calvary Chapel and its pastor, Reverend McCoy. They have been holding indoor religious services since May 31st, 2020. At that time, the governor had instituted the reopening plan, and so indoor religious services were permitted. However, they were holding the services with no masks and with no social distancing, so they weren't in complete compliance. However, the big issue came on July 13th when the governor rolled back many of those reopening plans, including prohibiting indoor religious services in counties that are on the monitoring list. And Ventura County is on the monitoring list, as are most large counties in California currently. The church continued to hold the indoor services. And I understand that Ventura County staff reached out to try to get voluntary compliance first and try to work out a solution with the church, in particular looking at finding venues for the outdoor service, because outdoor services are allowed, but that was not successful. So earlier this month, at the beginning of August, the County Board of Supervisors voted 3-2 to move forward with a lawsuit against the church in state court. The county was successful in getting a temporary restraining order where the court ordered the church to cease the indoor services. But even in the face of this order from the court, the indoor services have continued. And it really highlights the difficulty in this situation and the kind of intense emotional reactions on both sides. The church and the congregants have a heartfelt belief that they need to do these services and that the only place they can do it is indoors. You also have people in the community that are very concerned with the health issues that come up, and this photograph here is actually protesters protesting against the indoor services at this church. So then the county needed to decide what they were going to do next, and they did actually move forward with triggering contempt proceedings. The contempt proceedings are before a different judge than the judge that issued the TRO, because the church sought to have the case moved to a new judge, and it's before Judge O'Neill. Judge O'Neill, just this past Friday on August 21st, held the contempt proceedings and noted that he was not ruling on whether he would have issued the TRO. He was simply looking to whether the court had the jurisdiction to issue the temporary restraining order and whether there had been a violation of that order that resulted in contempt. And Judge O'Neill found that there was. So fined the church $3,000 in contempt fines. The pastor was not individually fined. So that was this past Friday, August 21st. August 23rd, on Sunday, the church continued with its in-person services. So again, really highlighting some of the difficulties here with getting compliance. The governor in his news conference yesterday indicated that new guidelines were coming out. As Deborah said, those might be on a Friday or on a Sunday. He indicated that some of those updated guidelines may be focused on the religious services. So we may get something from the governor that allows the county and the church here to resolve their issues without continuing with court proceedings. However, the next step in the court proceedings are a preliminary injunction hearing that is scheduled for August 31st. And if we can go to the next slide. Thank you. Businesses also have very restricted activity, many of them with the COVID-19 restrictions, and there's been issues with both compliance and enforcement here too. And we'll look at some of those if we could go to the next slide. Thank you. This case is a case that Deborah and I are working on together, Best Supplement Guide versus Newsom et al. This gym is located in the city of Lodi in the county of San Joaquin. When the governor's stay-at-home orders first came out, there were lots of lawsuits by churches, but this gym also sued, alleging a panoply of constitutional violations. We successfully defended against a TRO and preliminary injunction before Judge Mendez out of the Eastern District, and we hope to have the case terminated, finalized on our motion to dismiss, which a hearing will be held at the end of October. But in the meantime, there have been some complaints that have come to the surface that the gym may be continuing with their indoor activity. However, at this point, we don't have, as Deborah was saying, the concrete evidence of photographs or that type of evidence that would justify moving forward with an enforcement type of action. I do know that Lodi, as have many local jurisdictions, they've relaxed the permit process and the ability to hold these types of services in outdoor locations like parking lots. So this gym does have a large parking lot where they can do the outdoor, offer their classes outdoor. Now that can be quite challenging with the heat wave and the smoke. I do know down here in LA, I get lots of emails from my gym about the outdoor classes that they're offering, and I have not been, and I don't know if that's because of my caution over COVID-19 or because I just want an excuse not to go exercise in this heat. But I do know that lots of jurisdictions, lots of businesses have been working in their local jurisdictions to come up with creative ways to allow their businesses to continue while also complying with these health orders. I also just wanted to highlight that in a separate state, in New Jersey, there is a gym there that has continued flouting the public health orders and really irritated the judge there with contempt fines that are over $100,000. That is pretty unusual to get that, and probably is going to get the attention of that gym in New Jersey. All right, if we could go to the next slide. Bars and restaurants, also there have been compliance issues throughout the state. I know that LA County code inspectors found large percentage of bars and restaurants that weren't complying with the masks and social distancing requirements. The approach has really been citations, education, and I think the vast majority of instances that has been a successful approach. As Deborah mentioned earlier, however, when you have a situation where people simply are not respecting the underlying orders, you're going to have some real challenges. And I know that El Dorado County has had that with a couple of restaurants up there. 2 restaurants in particular, and then a 3rd restaurant recently joined in, are continuing to offer indoor dining with no masks, no social distancing, which are contrary to the current public health orders. And again, just to illustrate kind of how this can become very intense for people, one of the restaurant's owner has referred to these public health orders as a type of domestic terrorism. So that's pretty inflammatory language. The county here, I know, reached out to see if they could come up with a solution. That wasn't successful. They've put on steady pressure. They haven't responded in a outsized way, but simply have pulled the health permits. The restaurants are still operating and are starting to accumulate quite a large amount of fines. So the 2 restaurants that initially have refused to stop the indoor services, they're up to over 6,000 in fines each. One restaurant, like I said, joined recently to start the reopening, and will start the assessment of fines as well. The county indicated that after 90 days, if the fines are not paid, because they're not being paid, it will send the fines to a collection agency. So this form of steady pressure may get compliance eventually, but very, very difficult situations. Can we go to the next slide, please? This case, Tesla versus Alameda County, is a slightly different issue. Tesla sued Alameda County after the state began the reopening measures, but Alameda County still had stricter public health orders in place, because the counties, of course, can have stricter public health orders. They just can't have ones that are less restrictive than the state. Because Elon Musk wanted to reopen his car factory. No emergency relief was sought, no TRO, and this was really viewed as a leveraged effort to get the county in discussions so as to allow the plant reopening. And it appears it was successful, because they did come to an agreement and the case was voluntarily dismissed. We can go to the next slide. Schools. Well, this is a hot topic. The school year has started for many kids, but not in person. A lot of the schools here in California are opening online. If we could go to the next slide. So in California, as I think everyone probably on this webinar knows, schools cannot open for in-person learning if the county has, if the school's located in a county that's been on the state's monitoring list. Once you're off the state's monitoring list for 14 days, you can look at reopening your schools for in-person learning. There is a waiver process for elementary schools. So it's going to be interesting to see what happens in the coming months. There are two counties, Orange County and San Diego County, that have recently come off the state's monitoring list. Some cities in Orange County have been very vocal about wanting to get back to in-person learning. So if they stay off the monitoring list for 14 days, I think we can expect to see the public schools starting to open up again there. And there may be issue. I mean, we've seen the reopenings in other states, and it's not without its own issues. In San Diego, the San Diego Unified School District has said that they do not expect to have in-person learning in the next couple of weeks. It would be more the next couple of months. They say that they are relying on their public health experts and are putting in place more stringent plans. They don't feel like the governor's restrictions are actually strict enough to deal with potential outbreaks from COVID-19. So there's going to be some divergent approaches here based on the different communities at issue. If we could go to the next slide, please. Then there's also litigation. So we already have a lawsuit that was filed challenging the governor's restrictions. This lawsuit was filed July 21st on behalf of parents and students, and it's not a class action. They sought a TRO to restrain the enforcement of the governor's limitation on in-person learning, and Judge Wilson recently denied that TRO. There'll be a preliminary injunction hearing. This slide says on August 31st, but after the preparation of this slide, the hearing was pushed out a bit. So that hearing will be on September 10th. So that's one to keep an eye on. It'd be interesting to see the determination there. And also recently, I think it was just in the last day or two, there has been another lawsuit filed challenging the governor's order. And this lawsuit has been brought on behalf of religious institution schools that are challenging the limits on this order as well. And on the enforcement front, Deborah and I have both been hearing from folks that there are schools, I think it's primarily the private schools, have been reopening, but under the guise of being a camp or daycare, because camps and daycares are allowed for in-person with some, very strict distancing rulings. So there will be some real enforcement issues here and litigation issues that we're all going to want to keep our eyes on. If we could go to the next slide. In-person religious services. So I've touched upon this a little bit earlier with the Godspeak Calvary Church case, but just wanted to also, if we can go to the next slide, give a very brief overview. The churches were some of the first to sue, challenging the governor's restrictions. The South Bay United Pentecostal case out of San Diego went up to the Supreme Court, and in a 5-4 decision, the Supreme Court rejected the church's attempt to restrain the enforcement of the COVID-19 restrictions against their in-person services. If we could go to the next slide. Justice Roberts joined the 4 more liberal justices in this decision, and I've detailed here the key points from his opinion. One thing I want to call out here is that he really emphasized that the court should have deference to the politically accountable officials in this emergency situation that's fraught with medical and scientific uncertainties. We could go to the next slide. Calvary Chapel case also went up to the Supreme Court recently, challenging restrictions on the church's in-person services as well. It was the same 5-4 split decision. The majority did not issue any kind of opinion. I did want to just note that Kavanaugh in his dissent was, very, the dissent was very focused on the fact that that these limitations on the in-person services were unconstitutional. However, Kavanaugh did note that the court should be very deferential when states are considering limitations on secular businesses. So that's a key point just when you have the lawsuits that are brought by businesses. We could go to the next slide. This is a listing, in addition to the South Bay Pentecostal, of other cases percolating here in federal court in California. Deborah and I have been involved with the Gish and the cross-culture cases. And then there's also the Abiding Place Ministries and Calvary Chapel. So all of these very winding their way through the district court and Ninth Circuit. If we could go to the next slide. And so far in California, the courts have rejected the challenges by the churches. I should say the federal courts. There was one California court that found otherwise, but the appellate court then has reversed thus far. But in New York, there was a case where the churches were successful, or actually I should say religious institutions. I think in this case, one of the plaintiffs was a synagogue as well, in having the court restrain the governor's order. And that's because the court found that the limitations on some secular activities were more permissive, and that there was no constitutional basis for that. Outdoor gatherings such as protests and graduation ceremonies were allowed on a much more permissive basis. So if we can go to the next slide, please. Public protests and rallies. Let's go to the next slide. First, we'll look at public protests and rallies kind of through two different lenses. One through the restrictions from COVID-19, and then next we'll move to looking at, in the wakes of all the protests that have been happening recently, what type of constitutional tools local jurisdictions can use to ensure the safety of their community, while also really making sure not to violate the First Amendment rights of their citizens. But first, let's look at the COVID-19 restrictions. The Givens case, in this case, the plaintiffs challenged the stay-at-home orders and their inability to get a permit for a protest and a rally on the state capitol grounds. They wanted to hold the protest and the rally on May 2nd and May 3rd. So the TRO was denied here. The case is also on appeal to the Ninth Circuit. Of particular interest is the plaintiffs are now trying to work into the case issues of uneven-handed enforcement, saying that the Black Lives Matter protests were allowed on a much more permissive basis. So some interesting issues that are being woven into the case now. If we can move to the next slide, please. This is a case out of the Seventh Circuit, also dealing with public protests here, or actually not public protests. This was a political rally. So the Illinois Republican Party wanted to hold a political rally, and they wanted it to be on July 4th, and they wanted to be allowed to have more than 50 participants. The governor's order limited it to 50. They claimed that because religious gatherings were permitted to hold their gatherings with more than 50, that this was an unconstitutional content-based distinction. So this did not hold water in the district court or the Seventh Circuit, and then when it was appealed up to the Supreme Court for an emergency restraining order, Judge Kavanaugh did not even refer it to the full court, but simply denied it. One of the issues that came up in the briefing was whether there was selective enforcement such that the governor's order was unconstitutional. And the courts found no, that there wasn't, because Black Lives Matter protests, there wasn't enforcement against those protests, but there also wasn't enforcement against the Reopen Illinois protests either. So found no selective enforcement here. Okay, if we can move to the next slide. Protests and curfews and restrictions. Let's move to the next slide. Public protests. Oops, sorry about that. As Deborah mentioned, this is some intense, very intense times for us. Not only is there the COVID-19 pandemic, but also very, very intense protests going on. So if we can move to the next slide. And here in California and across the nation after the murder of George Floyd, there were protests in many, many communities. And those protests in some jurisdictions triggered the implementation of temporary curfew orders. That's an extraordinary power that is limited to emergency situations. And on this slide, I'm just going to give a quick overview of the key points that are needed in order to make sure that a curfew order is going to pass constitutional muster. Needs to be limited, needs to be directed at addressing a substantial threat, needs to be related to a compelling government interest, and you need the even-handed application. We could go to the next slide, please. In California, the key case to look at for curfew orders is the In re Juan case. That case involved a curfew that was enacted by Long Beach after the Rodney King verdict, and there was rioting and looting. The court there found that the curfew order did pass muster. The city had declared a state of emergency. The curfew was limited, and it was directed at and supported by a compelling government interest. We can move to the next slide. So more recently, we have had the Black Lives Matter and George Floyd protests. Here in Southern California, many cities enacted these temporary curfews. The Santa Monica and Beverly Hills had quite restrictive curfews on a couple of days, starting at 1:30 and 1 p.m. respectively. I don't believe that those curfews were challenged in court. If a curfew is challenged in court and you have a curfew that is this restrictive, you really want to make sure that you have that compelling government interest. And I think Santa Monica and Beverly Hills were motivated to put these restrictive curfews in place based on some looting that had been happening in their jurisdictions. City of LA also had a curfew order in place from 6 p.m. to 6 a.m. on June 1st and June 2nd. They actually did have a lawsuit that was brought by the ACLU on behalf of Black Lives Matter that was filed on June 3rd. That lawsuit was, however, voluntarily dismissed because the curfew orders were no longer in place and they were not being re-implemented. So if we can move to the next slide, please. We certainly hope that we're not going to have the type of intensity that would lead to further needs for any type of curfews. But, you know, unfortunately, we're seeing that protests or issues of protests are continuing, and, you know, there's continuing issues with shootings, and these are leading to the protests continuing throughout the country. We also have a very fraught political situation with intense views on both sides in an upcoming election in November. So jurisdictions are going to really want to be looking at what can they do to allow the First Amendment activity to continue and that outlet for protest, but also keeping their communities safe. Curfews, again, are really, you have to have that compelling government interest. But there are other tools that are available to jurisdictions to help prevent any type of violence happening at protests and other types of demonstrations. And one case out of the Ninth Circuit is a key case to look at to limit the types of tools and other objects that can be used or taken to protest. And in this case, plaintiffs were wielding a bullhook, which is a large piece of long wooden piece with metal at the end. And they were cited for having that because the LA code restricted the types of objects that could be taken on protests and limited the length of these of wooden objects for safety reasons. And the district court and the Ninth Circuit both found that these limitations on these kind of large wooden pole signs that also went to this bowl hook were content neutral and only had incidental limits on First Amendment expression. So if we can go to the next slide, please. Deborah and I I think it was a year ago now, had an issue come up in Modesto where Modesto was concerned about potential violence at an upcoming event that was happening in their jurisdiction. It was a straight pride parade event. They had information that there would be the Proud Boys may be attending and other types of white supremacist groups. There were going to be large counter protests, including some information that Antifa might be showing up. So in the wake of Charlottesville and the tragedy that happened there, the city wanted to do everything that they could to make sure that they could allow the First Amendment expression to take place, but limit the potential for violence. So we worked with them on having the city adopt an urgency ordinance, which they did, to limit the types of things that could be taken to protests and demonstrations to prevent objects that could be weaponized from showing up at these protests and demonstrations. So we were very thorough, put very thorough findings in the ordinance, and then the ordinance itself limited the types of things that could be taken to the protests, banned bricks, glass bottles, chains. Interestingly, we also decided to limit the use of super soakers that apparently now is one form that protesters and demonstrators will use from both sides, fill it with noxious liquids, and it can be used in a very negative type way at these protests. So this is also something that cities have in their arsenal to allow the First Amendment expression to continue, but limit the ability for violence to erupt. And I think now, Deborah, I think this is our last slide. I know we'll have some final thoughts and then questions, but Deborah may also have some thoughts on this urgency ordinance that she wants to share as we worked on this together.
Well, thanks, Meg. I think the main thing is, I think we should just point out that to the extent you can adopt time, place, and manner restrictions that don't impose a serious curfew, you're ahead of the game and probably going to be less likely to draw yourself into a legal challenge. I know that there was a lot of issues with those curfews that were ending here in Los Angeles County that early. People couldn't get to the grocery store, people couldn't get to the pharmacy to get their prescriptions, and it was a very early time. I think we also got some questions about whether or not if you knew a protest was happening at 2 o'clock, you could impose a curfew at 1 o'clock. That was kind of an easy one, and the answer was no, that would be content-based. So I think that, we talked a lot about the legal framework. I think that we leave it to each of your local communities to understand the dynamics of your community, and that sometimes the imposition of a curfew is going to incite more unrest and incite more potential violence. And so those are the balancing that the decision makers get to move through. Again, challenging times. I know I was just reading in the LA Times this morning, big protest last night in Los Angeles. I didn't get to read the whole article to find out exactly what enforcement was taken. I think they declared it an unlawful assembly about 11:20. I know I was really struck. I usually do my workout about 6:30. And I was getting beeps on my phone. I couldn't do that. So I think that any curfews before sunset, I think are going to be very difficult to defend. So I know I promised Megan I wouldn't get into any judgment, but then again, I think I just have to give our best legal advice. So I'll offer that and put it back to you, Ms. Megan.
Wow, thank you both so much for all this great information. It was so amazing. We do have some questions coming in, so let's briefly tell you how to ask a question. At the end of bottom of your screen, there's that Q&A box. You can type in your question. If somebody has already typed in your question, feel free to hit that thumbs up and we will get to as many questions as we can. Like Deborah said, this is not legal advice. If you have any specific legal questions for your city, please consult your city attorney. The first question we have, ladies, is about face mask usage. So what about face mask usage for people who have disabilities? Can a store refuse service? Can a store refuse service for anyone who's not wearing a mask? Has an ADA come out regarding this issue?
Meg, I'm not sure that I am aware of any ADA guidance on this. I know that there is an ability to have an exemption from the face mask for disabilities. So our comments were generally directed to wearing a face mask without the exceptions applying. I'm not sure if anyone is getting enforcement questions where PD or code is being called because folks won't wear face masks. I think we've all probably heard of the issues arising where the managers are faced with trying to cajole people into compliance. But I'm sorry, I'm not very helpful on that one. I think it's still developing there.
No problem. You know, like we said in the beginning, everything is changing so quickly. So again, to let our audience know, you can review this PowerPoint and this presentation on the League's website at cacities.org/coronavirus. Our next question is, with regards to the courts for an injunction, the recommendation was federal court over state court if there is an avenue to do so. What are some of the better theories to have federal jurisdiction to file in federal court?
If you have a issue that has a constitutional right, and so generally speaking, the only way to get into federal court, I believe, is if you are sued first by a user. If you're sued by a church that says you're violating the First Amendment rights, or you're sued by a bar owner or Tesla, etc., then you could respond or attempt to respond. Everything is nuanced here, so I'm not sure that it's a guarantee at all that it would succeed. In federal court, you have to have Article 3 standing, and that's very difficult to establish, or the courts are very specific about that. So most enforcement actions, as everyone probably knows, are in state court. So it's probably wishful thinking on my part that a state enforcement can go to state court.
Yeah, and that's what I would say as well, that most of these enforcement actions we're going to see in state court. But it is always good to be aware and have in the back of your mind, if there is any potential hook to get into federal court, that would be useful.
Great. So this is about Wildan. Did I hear correctly that Wildan is issuing administrative citations for violations of municipal code? If Wildan is doing that, under what authority are they doing that? Does the municipal code allow for agents or designees to do so?
That's a great question, and I think that, thank you for that. I think the listeners really cluing into what I was discussing, which is you have to go back to your code to see what is authorized. I don't know what Hermosa Beach code says. What I know is that the Wildan is assisting the Hermosa Beach PD. They have no arresting authority. So I did understand that they were issuing citations, but I haven't seen the underlying basis to confirm that it's authorized in the code itself. I would think that as we have used Wildan to do things like planning and plan check and engineering, that as well there would be a vehicle to use Wildan for issuing of citations. But consult your city attorney.
Perfect. Going back to face masks, can a store require a face shield as an alternative to a face mask? And have you heard of any companies refusing to service if neither is being used?
I haven't heard of anyone refusing service, but I have been at a to-go facility where I wish they had, and but in any event, I believe that they could. I think I had a slide that says no shirts, no service, no shirts, no shoes, no mask, no service. And I think that an individual business owner is free to deny service to anyone, including those not wearing a face mask.
Yeah, I haven't heard, other than kind of anecdotally, and certainly reading in the news, I've heard of situations where businesses have asked people to leave for not wearing a face mask. And I would agree, especially here in California, where we have the health orders in place, that businesses would be within their rights to ask people to leave not wearing a face mask. And I think oftentimes many of the other patrons of that business, would appreciate that.
Thank you. I'm going to go to Catherine's question about, is anyone talking about the tension between SB 946, generally permitting street vending in most circumstances, and cities taking action to prevent COVID crowding on streets?
I haven't heard any discussion of that, but I did do a speech on street vending. So I actually did see street vending still existing in COVID-19. So it's a great question. I don't know.
Yeah, I haven't heard specifics about that either, but I could see that continuing to be an issue, especially with the emphasis on having activities taking place outdoors. So you have a lot of businesses moving their services from indoors to outdoors. So I would think that there would be maybe even more of an emphasis on having that kind of sidewalk vending. I think with masks and certain elements of social distancing, it's probably a more recommended way of moving forward in this current health crisis issue.
Yeah, having that sidewalk vending and companies moving into parking lots has been a topic that League members have been talking about on our roundtables. So if you're interested, make sure that you pay attention to your listserv, because we've been doing a lot of roundtables throughout the department. So please let us know if you are not getting that information. And roundtables are another great way to talk to other cities about what they are doing. So we do have time for a couple more questions, as long as our speakers can still stay on. Council eliminated Code Enforcement Department in 2019. Who else would be authorized to monitor and educate?
Great question.
We don't have a code enforcement. That is a great question.
Yeah, many times in cities it varies. So sometimes you have a separate department under police. Sometimes I've seen it separate under building and planning. And so again, it would be, consult your municipal code and with your city attorney about now who has taken over those functions. And of course, then it gets back to the earlier question, who can those functions be, can outsource to, or who is an appropriate designee to administer that? I would think it would be within those two departments, but compliance may vary depending on each jurisdiction, and with budget cuts, there may have moved things about.
There's also the potential to reach out to the state strike teams, but I think, Deborah, as you had mentioned earlier, we're not hearing that there's been much success in reaching out to the strike teams, but that is something to keep in mind as well.
Yeah, and I think I see later on in some of this questions and answers, one of our colleagues attending says that they've gotten absolutely no response from the state strikes team. So that seems right now not to be a very active or effective option.
Yeah. So, continuing with code enforcement, can a city code enforcement administratively enforce county health orders?
Yes.
Easy.
I just go for that one. I hope I'm right.
I'm going to go to the top question. Please address the retail inside and outside and retail inside of a mall that all sun vendors, I don't know, or sun vendors open but not allowed to open. I guess some vendors are allowed to open but not all. And also the state ordinances of any business outside must not have two sides closed when using that pop-up tent, including salons. Can you speak, and they say thank you so much for all this great information. Can you kind of speak about that, those vendors who are inside a mall, outside a mall, and the tent issue? Have you come across any of that?
That is one provision of the state regs that I have not read. We have a bunch of charts about all the regulations, but I don't think this one has made it onto there. So I have to we have to dig back into the state's website to figure that one out.
Yeah, I'm not sure of the details for that type of indoor-outdoor vending either. I know that the governor's planning on updating the guidelines and emphasized in his news conference yesterday that some of those updates will have to do with hair salons and beauty salons. So I know there'll be updates coming out that maybe talk about the indoor outdoor for them, but I'm not sure if it'll address the mall situation as well. Certainly, I think just from a legal standpoint, the distinctions of which type of businesses can operate where, the courts have indicated that they'll definitely have deference to those decisions that are made by the politically elected officials and the health experts.
I'm not sure if you have a lot of information on this, and I believe it is about the mask issue, but do you know why the state withheld funding from Atwater and Coalinga when other cities did not follow that ordinance, or is that too, feel free if that's too political?
Well, I don't think we know the specifics. I see that question calling out another jurisdiction. If the other jurisdiction had adopted the same ordinance that specifically, proactively affirmed they were not going to enforce the state's orders of shelter in place, then I have no idea why there wouldn't have been consistent treatment. But I would go back to my issue of right now, the state seems to be requiring an ordinance or resolution. And so tacit refusal does not seem to be enough to get you into the state's crosshairs.
Perfect. We're going to do one more question and then go to the final thought. Do you have any tips, best practices for dealing with code enforcement actions, especially to groups who are unlikely won't respect court orders or have little money or property to satisfy the fines, and the jails will be unlikely to hold them?
These are the really challenging and troubling issues. I think you have to strategize hard on what your objective is. Is your objective to get someone in jail? Is your objective to get someone with a face mask on? Is your objective to get the restaurant outside? And then try to structure yourself to achieve that objective. So, for example, in my example about the guy dumping 800,000 cubic yards, he's never going to pay that fine. But what we wanted is to stop the trucks. So we got an order that stopped Class 6 trucks. And in state court, I would urge you to use your strategy of getting the best judge that you can get. That will hopefully give you a strong order to achieve your objective. And that is not easy, and good luck to you.
Well, I want to thank both Deborah and Meg for all your great examples and tips. We've gotten some great questions. This is a point where I want to ask, do you have one final thought leaving our audience today about code enforcement and First Amendment rights? Is there one final thing that you want to tell them, like a good takeaway?
I'll start here. It's probably more than one thing, but I'll wrap it into one point. These are difficult times, and this is really a marathon, not a sprint. So it really requires the kind of calm, consistent, steady pressure, working with your team, figuring out what the objectives are, trying to do education and buy-in from the stakeholders, and then from there, figuring out what your plan is and moving forward in both with flexibility on what the situation is and in a very even-handed manner.
And my final thought is along those same lines, which is take a look, open up your municipal code, find out what your code enforcement provisions say, see if they need to be revised, see if you want to supplement them, and then to be extra kind to yourself. You folks are on the front lines on a challenging item, and you can't take care of your community unless you take care of yourself. So please take care during this most challenging of times that we're all facing.
Oh, thank you so much. Before our audience leaves, I just want to make a couple quick plugs about League membership benefits. Please join us Thursday for Equality and Justice webinar. This is the first of our this series. You can sign up using cacities.org/events. That will be on Thursday, August 27th at 10. And also, please sign up for our first virtual annual conference. We look forward to seeing you virtually, even though we can't see you physically, and that is October 7th to the 9th. So please go back on the League website and register for both of those events. Thank you so much to our speakers. You ladies are amazing, and we really appreciate all the information that you've given us today. Thank you so much. Thank you, Megan, and the League staff. And everyone have a safe Tuesday, and please stay safe. Thank you so much.